Good morning.
Good morning, how are you?
I'm good now that we've had breakfast after much confusion on whether or not we're having breakfast.
Yeah, I can't understand how you misunderstood that. That was pretty
I
straightforward.
asked you, are we having breakfast? And you said no brekkie.
Now you asked, are we meeting at the office or breakfast? And I said, no, brekkie.
Yeah, you're missing a comma, which is, anyway, doesn't matter. So
you said you're intuitive.
Yeah, okay. You're sharp, aren't you? You've had 9 hours sleep. 9 hours sleep.
Yeah,
After a very big week.
A very big week. It's been a lot of fun, hasn't it? We've done governance training, leadership training, and then yesterday a whole day in Sydney in enterprise bargaining training, which was a lot of fun, meeting 7 new people in a business, all who are really successful, trying to work out how to do a national agreement. Yeah, it's fun doing that sort of work.
Oh, good. I do lots of work too, but I'm somehow just recovering from the idea of not having a child with me after 2 weeks of having children around me being unwell, and then another week of having one child at home because of another illness. So, but,
and the nice part is you paid for all the care even though they weren't there.
Yeah, thanks for reminding me. Tell me it gets easier.
I can't because I had teenagers. I'm out the other side. No, it does get a lot easier once they're past 25 and they're not home. But remember that people stayed home as well. So we had a house full of kids till quite late. So we're empty nesters now.
Yep. No, it's been a demanding week. So I'm looking forward to the long weekend.
Yeah, it's been good to see people rally around because both Kim and Satyria had similar issues.
Yeah.
And I think COVID's taught us a lot about flexibility. But I think the driver behind this is how we respect people and how we still get work out, but we manage to accommodate what your needs are, like you taking time off and being completely blanked. Yeah. So everyone knows they're not to talk to during that time. Saying flexibility is one thing. Actually creating systems around flexibility so that when you're looking after Mark when he's at home, you have 4 hours to improve his education beyond his schooling.
Hey, it's part of the deal. I told you, you're better off just go to school. It'll be a lot easier for you than staying at home.
So I think the thing that we've probably learned most, not only through COVID, but we're doing before, is how do we build systems that support people who have caring responsibilities? Yeah. And how do we make flexibility work by actually having a deliberate system rather than saying, oh no, you can work flexibly, but I'll just ring you whenever I feel like it. So we need to work around that a little bit better. I think we're getting a lot better at it. But because we get called upon at short notice to answer problems. Yeah,
the nature of our work.
We've had to think very hard and make all staff be very deliberate about respecting those systems.
Yep, definitely.
So I think we're getting pretty close. We're 12 seconds away. We've got a number of people lining up already.
Yep.
Any big things for you this week before we kick off?
I'm not thinking beyond today right now. Yeah, to be honest.
All right, well then let's kick off.
All right, well let's go. So good morning everyone. Welcome to the Friday Workplace Briefing and a disclaimer.
And a disclaimer, yeah. Remember, this isn't legal advice. Both of us are quite sober and we're fit today. So there's none of the usual 0055 voices. There's no one marching outside.
You're a slacker today. You didn't do any PT.
No, but I did Pilates. And there's no one outside with signs protesting, which is really good. The cow's not here. That's even better.
Cash cow. Yeah.
Okay, well, let's kick off with the first couple of things. I want to talk, there's a couple of cases that have come through today. The courts are really quiet. I want you to understand that. A lot of stuff has been pushed off because of COVID, so we're not seeing the same volume of case law come through. We had a really good case in Road and Hinterland Motors, which was something that all of us are used to. It's my gossip case, I think, in this case, Road was about angry and resentful inside his business as the employee, and he made this naughty joke that he was going to put in a fraudulent workers' comp claim. Hinterland Motors didn't think that was a funny joke at all. In fact, they thought it was serious misconduct and they terminated his employment. When the Fair Work Commission looked at it, they said, look, there's no evidence that he was going to do it. This was a joke. It was a bad joke, but there's no evidence of dishonesty, which is serious misconduct, nor is there evidence of a predatory application to try and stitch up the business. There's a joke that was made about it. So there's no evidence, no valid reason for the termination. So I think it's an interesting case because commonly as an employer, and I know, I've headed large law firms, gossip will come up to you about the way someone is behaving and what they're saying and the level of angst you get around that.
Yeah.
is then self-confirmed by the people around you who are also angry.
It's very easy to react to that, isn't it?
Yeah.
And most people would.
Yeah. Because it's a clear breach of values. The problem is that you're inclined to talk to only the people who agree with you. And by the time you go to speak to the person, you're furious at them. And what started off as a prank or a foolishness and a cynical joke turns out to be something which is not enforceable and law is wrong. And you breach your own values by then stepping in to terminate and discipline. This was a good discussion to have with this guy and say, look, I heard you made this joke. By the way, not a funny joke. Can you talk to us a little bit about why you said it?
Yeah, I think it's really important to neutralise, if that something like that occurs, to neutralise the conversation and determine whether or not there is any real intention to do that. And if so, then actually support the employee in doing that. But if not, then the conversation needs to occur around the inappropriateness of those kind of comments.
Yeah, no, I agree. I think if there's somebody's injured, we should support them in the process. We should never try and say to people, don't put in a claim. So we never want to be the author of that particular idea. We're going to explore, Rode, by the way, in our problem today. We're going to stretch it a bit further and test, well, when does what somebody says become serious misconduct? Okay, so I think it's as I said, the case is not important. It's a bum case. It has no particular legal value, other than it starts to explore this issue, particularly around social media use. When what I write or say, when does that become just being silly and turns into something serious? And I think the most important part that Karen and I talked about over our rushed breakfast again this morning, was to make people understand you've got to de-escalate a lot of this stuff. You've got to find out what is the heart of it. And then once you determine where it sits, you can take action one way or the other. But you should always talk to people. I think that's the first part. So that's Rode. Simple case. We'll explore it a lot more a little bit later. The next case is Campbell and White. Campbell and White runs on a whole series of crane cases in safety law. For the people who aren't safety practitioners, this will sound crazy, but there are a whole range of cases over the last 4 or 5 years, culminating in the Queen and Watt, where a individual was charged with industrial manslaughter and eventually pleaded guilty to the lesser but still jail time charge of reckless endangerment, of cranes being consistently used above their load maximum. Okay, now you got to wonder why that happens, and the answer is because of expedience. So if I lift something up, I go, well, it's a little bit above, and the light on the crane tells you it's above, okay? But you go, look, it's not much above, and I just need to get this from here, and we'd have to unpack everything. Well, there's a reason why you have load maximums, and there's a reason why you have safety systems that sit around. Now, in this case, they were cropping pine trees. As they tried to do it, the trees split and the cables around the crane became entangled. Now, it doesn't take much for you to realise at that stage that when you're pulling against a tree that has strong roots, you're definitely going to go over the load level. As a result of what occurred, they didn't follow any of the systems around. Now, they're under pressure to get it fixed. They started pulling up, and of course, it didn't work, and the broken bit of tree swung up at high speed, just missing someone. So it was a near miss. Remember, in the Queen and Watt, it was a fatality. Okay. The court said, and the court can I just say that it's not uncommon for courts to get this wrong. The fact that they were unable to pay doesn't mean that they shouldn't have received a monetary penalty. They said they would have given the company a $150,000 fine, and they would have fined the director $15,000, even though it was a near miss. So it's a warning, because if you weren't an insolvent business, you'd have to pay that. But as I said, that's not right what that
It sends a very confusing
message. Yeah, the answer is some of our biggest awards have been in insolvent businesses, including the go-kart case. There was over $1 million of sentence done to a company that's in the process of being wound up. And the idea of that is to say to people, this is the tariff for wrongdoing. But for us, Karen, it throws up some really interesting issues about, one, repeated misuse and breaches of safety systems, which is this case and all the crane cases. And what the judges say about that very clearly is, you've got to have a safety system. If you do have it, and if you don't follow it, if you don't have a safety system, you're in deep trouble. If you do have a safety system and you repeatedly breach it for expedience, then you're in deep trouble. And the third thing I say is, look, the time a safety system really matters is when something goes wrong, like in this case, entanglement. Like in any case, like there's been an incident that occurs and suddenly you have to move something. It is that presence of thought to step back and say, what is the risk that is here? Is there a system that we use? And then apply it, which creates, because it's at urgent times that the greatest risk arises. Now, you've had that learning when you used to work at Toll. You've had all the experience before in training people. What's your response to this?
Yeah, like you said, it comes back to having a robust system, firstly, but a robust system means that people actually understand the system, understand how to use it, understand what they're required to do and when. So there's that part of it. And like you've also said, ordinarily, why does the system kick in when something terrible happens? Now, the system always is working, should always be working. So use the system, use the process that's in place to manage your environment, to manage the workplace. So rather than dealing with urgent issues, well, it's just not dealing with that particular hazard or risk at the time. Understand that the broader implications and impact across the whole operating environment.
Yeah. My nickname about this is called brake theory, which is, when you drive a car, because you practice, and the car brakes suddenly in front of you, your foot automatically goes on the brake. You don't think about it because it's practice. And the difficulty with safety is, if it's not practice, it's not done. And so when an urgent thing comes, the car stops in front of you, you put your foot in the accelerator. And that's sort of what happened in this case. When an urgent problem arose, rather than putting your foot on the brake, they just rushed ahead to try and fix it. And that's going to happen to you all the time. It's, why the five-step safety systems work. Step back, have a look, consider, analyze the risk. We've got to get people used to the idea of safety doesn't work unless it's practiced every day. And we've got some difficulties because in the safety consultant market, far too often they come in with a forklift full of documents and say, well, that's the safety system. And nobody can pick them up, let alone read them.
Yeah.
So robust systems are ones which are capable of understanding in the language of the people who are using it and are simple. A crane, it's really easy. A light goes off and tells you you're overloaded.
I will touch on that in terms of when things do go wrong, in terms of investigating them, but understanding the root cause of that, rather than when things go wrong, patched up, deal that, essentially make the matter go away at that point in time. But no, there is still fundamentally an issue, something's broken and not working. So understand that and actually do something about it. And then that's part of the whole system. Yeah,
and I think we've got to keep doing that. There is an enormous learning, even in near misses. Don't wait for someone to get killed.
Absolutely.
In this case, the court has gone through and done the analysis and said, these are the breaches that have occurred. But how could that possibly happen? Because the moment that light goes on and you're carrying, that's actually a hazard. So that's a hazard assessment process that should have gone on, and there should be some method of tracking that says, so you breached this, why? What's the learning from all of this? Now, look, let's move on. I know these aren't high court cases, they're not really exciting, but in the day-to-day stuff that you and I are constantly involved in, and in the day-to-day things that cause enormous risk inside business.
Absolutely.
So let's go on now and talk a little bit about enterprise bargaining. We promised we'd do the big issues for 2021. The really big opportunity at the moment for us, unquestionably, is enterprise bargaining. We're coming from a post-COVID time, which is terrific. When I say post-COVID, we're still right in the middle of it, but everyone is ready for disruption. Nobody has an expectation you're just going to roll the enterprise agreement, except probably the union. When there are massive changes that occur, like large restructures, all those sort of things, it is an opportunity to create genuine change and engagement, and you mustn't miss it out. So I thought what we might talk about today is I've given the 7 things you must do before we start to negotiate. And look at that, as I say that, Soph, ever vigilant, just goes like that and it's there. What I'm going to send out to you all today too is we've got a thing which is a much more fuller version of this that goes up to 12 steps, okay, which goes into enormous detail about what you need to do. But what I want you to remember is before you start negotiating enterprise agreement, you start about 18 months beforehand. And the first thing you want to find out is, what actually do your employees want? Because we don't want to get into position-based bargaining where you're fighting me. You're union, I'm employer, we're actually fighting. You put in a log of claims and I respond to them. What about our log of claims? And I also want to know that when I'm telling you what I'd like, it's actually something that's useful for you. I've found a narrative that engages you. So the sense of, and I hate using this phrase, win-win lives, rather than the oppositional bargaining where everyone loses and we end up with a compromise. So an enterprise agreement where everyone loses ends up just being about money. And yet we know, as you can see in item 2 there, an enterprise agreement is an imposition on the business that you've got to do every 3 years. It's a key driver in wages and conditions in your strategic plan. So it belongs inside the strategic plan, not sitting out the outside where everyone says, oh, it's time to send out our employee notice. It's 3 months before the nominal expiry date. We better get going. So first of all, find out what your employees want. And the way to do that is there's 3 major parts to it. The first part is to start engaging your supervisors in the change and have them and explain what you're going to do and how it's important for them to find out what's affecting and to get their opinion on what's important for employees and to remind them that they will be part of this team going through. Now, some of those supervisors, they're going to be actually members of the union. I don't care. They're your supervisors, and what we try to do is not keep them close to their friendship group, but elevate them so they can be leaders and have some ownership and accountability in the operation of business. Then we do a survey, not a really complex survey, a survey which picks up how people feel about the organisation, because we actually need to know the temperature of the organisation. What are the issues that are worrying them most of the time? What are the things they like most? Remember, we're not asking for the problems. We want temperature, things that would help them, things they're happy about. Because when you're in negotiation and people say bad things like your guys are so unhappy, well, we've got the data that says, actually, you're quite wrong about that. You need temperature. Then you go to a focus group with those key informal leaders in the organisation to flesh it out so you get some colour and character about what you get, and you get some stories. Stories in a negotiation are the most powerful tool. So when someone says everyone's unhappy, say, well, let me just tell you a story about how unhappy people are. And you've got a story which involves their delegate and a few other people saying how lucky they are to work here. So
if you don't tell the story or own the stories, they'll give you stories.
That's right. And they won't be true.
That's right.
So get in the strategic plan, and remember, we're not looking 3 years out, we're looking 10 years out. All our businesses are going through rapid periods of disruption at the moment. We need to know when that disruption's arising, because what we can't afford is to do a EA that's 3 years out when disruption's arriving at 2.5 years, because you're going to have a bomb of an enterprise agreement. And we also need to start readjusting the enterprise agreement into the downtime in the business rather than the busiest time of the business. So think about when it lands, really important. Get your key staff to go through the EA and go, what's good in it for the business, what's bad in it for the business, and what's neutral. You always find that if you've got a normal union-based EA, there's almost nothing in there that's good. So there's no tools for your supervisors, it's just all punishment. Well, we want to change that. It's COVID time, flexibility provisions, stand-down provisions, a whole lot of things we can introduce in there which create real value for the business about how we move shifts, what we do.
Definitely, and more now than ever before, because previously those clauses or provisions were things that you just kind of, scan your eyes over and really not pay much attention to.
Yeah, and look, everything has to be useful inside an enterprise agreement because it's in your supervisor's toolkit. What I like you to do then is to sit down and actually draft the perfect EA for the next 3 cycles. So you know in relation to your projected changes in your business that you have an enterprise agreement on each one that totally does what you need. Now, will you ever use it? You're not going to get everything, but then we go through during our SWOT analysis and we prepare what we really need, which we call our golden rules, the ones we can't walk away from, the things we love, and our bargaining chips, the things which, gee, it'd be lovely to get, but it's got a value and we'll see what it is. And then we go and price the entire enterprise agreement. And when we do that, we talk about total cost, not just percentage rises. So we look at how that goes in FPT, we look at all of those parts. And then to each business group, we go back and say, so here is our spreadsheet, and we've got a calculator in it. If I move 1% here, so let's use a classic thing. If I put up the wages by 3%, the cost of business, total cost of business, is usually 4.5%. And remember, that's accumulating. So the next year, 3% pushes you up over 10%, because that's the true cost of business once you put in all the provisioning. So can you remember 3% is not 3%? You must do total cost analysis. You must do SWOTs so that you actually know what are the opportunities you're missing out, what's going on outside in the environment. We've done an examination of all the enterprise agreements, which is an absolute must, both geographically, because that's where you're hiring people from, and business related, because the union will always come through the door and say, you guys get more money down the road. But you need to look at your pricing structure for what you're doing and wages. You need to look at your competitor, and if they're paying more, well, maybe that's because their product's a much more expensive product. Where's your story when you turn up in the negotiation? Remember, the employer argues always from evidence and fact. We are good people, always being good, sincere, and in control, because our stakeholder group, principal stakeholder, are the 3 delegates who are sitting across from you. There are all the employees in a business. They're our stakeholders. So we can never engage in the sort of crazy behaviour and the hijinks that gets on with unions. They have to say, gee, I want to work for these people because they know the truth. They know about our product. They know about our competitors. They know about the people locally. They're actually really looking after us. They've thought about those things. And
it's really easy to just maintain calm and focus when you know your stuff.
So the next thing is prepare your strategy. Okay, so work it out. You've done all that hard work. Can you please document your strategy? Don't have it up in the air. You should have clearly stated at this stage, what is the purpose of the business? You know, we provide legal services and training to employers, we only do employers, to create value for those employees and their management of people in the workplace to improve their productivity, quality, and in profit businesses, their margin. That's what we do as a law firm. We're a creator of values. Now that means if I had an enterprise agreement, everything in my enterprise agreement must create those elements of my purpose. Please don't get distracted by the complex strategic documents that break down values, do all that sort of stuff, have visions. I want you during enterprise agreements to be totally clear about what is the purpose of the business. And anything that doesn't align with purpose, you want out. So you don't want disciplinary policies stuck in your enterprise agreement. You don't want those sort of things because
peak policies.
Yeah, you don't want
safety
those
policies.
Yeah, they don't belong there. Okay, this is a minimal document. So prepare your document and then get your strategy down to 3 or 4 lines. Work out what the strategy of the union is going to be. You will have found that out. It's always going to be around money, competencies, redundancies. It's all going to be cost. Okay. So what's your answer to that? You must have a clear narrative, because what you're saying is we want people to come with us on our journey. What they're saying is not coming with us. You'll get looked after financially by us, because in the part of strategy is if we're going to go up by 3% in wages, the business has proven a case that it can recover that 3% completely through business innovation. Remember, you cannot do an enterprise agreement that costs money. It must be cost neutral. And that means you must get your CFO and other people involved to actually determine, well, if we're going to give away 11% over the cycle of 3 years, how are we actually going to recover that given the nature of product, service change, the disruption that we're going to have? What are we going to do to get there? Because you can't give it away, because components are going up in price. All the taxing processes are going up. If you just let wages going up, actually it's a zero-sum game. There comes a stage where you're actually not making profit. Unless you're innovating and recovering that cost, you're just getting more expensive capital every year. So you've got to make it cost neutral. And the last part, and we're both giggling about, is not only have you got to train your negotiation team, you've actually got to choose who's capable of doing it.
Have the right people, have the right people on your bargaining team.
Because there's some people who just can't do it, aren't they?
Well, often you might have operational people sitting on around the table, which is fine. But every role at the table should have a purpose. Rather than just being there to provide just to be an observer.
So look, what I normally would do is, if you've got a larger organisation, you've got 3 people there. There is the leader of the negotiation. There is the documenter. Remember, you must maintain perfect documentation of all the iterations. Always create at the end of it, what are the minutes? Because these are going to go straight out to your employees, and we'll talk about comms in a second. But if you end up in court, that timeline of everything that occurred, every email, all those things in order, allows me to prove what the intention of bargaining was. And so when the unions say that was never our intention and they don't keep notes, we can say, no, here's the clear intention, here's how it was documented. Please, every change you make to an enterprise agreement going through is a clean iteration. So at the end of the day, you don't just keep marking it up, you mark it very boldly on the top. bargain as of such and such a date. Okay, and the changes that you made there are clearly in a different colour, so you can actually see the changes that were discussed. It's terribly important. And look, the comm strategy for me is really simple. The unions will come at you fairly aggressively in negotiations, so you agree when paid feedback happens. You allow yourself time, so you're out there beforehand. You bring your supervisors into the communications. They're the people who go out with you to communicate at a toolbox level, not mass meeting. That just shows you're trying to steamroll people. It's at a daily, weekly level. You're able to answer questions for people. They get a copy of the minutes plus a brief analysis of it. Everybody gets that copy. The unions will not necessarily tell the truth when they come out. You are the only truth teller. And they also lose momentum when you take control of communications. If you don't, they build momentum and suddenly the cost of negotiation goes up. Remember, the longer the negotiation, the more expensive it is and the more your employees get drawn into it. So these are pretty important things around comms. Stakeholders, your other stakeholders, of course, are your steering committee. We're not talking about steering committees today, but I have a steering committee document that I'll share with you after this, which shows you what you've got to tell the members of the steering committee, and they must sign off before you start bargaining. And that gives you the parameters of what you can and can't do. Never go back. They've got to say, this is the deal, and you've got to put the business case for the deal. They're one stakeholder. The second stakeholder clearly is your customers. You've got to tell them you're in the middle of bargaining. You'll find they're incredibly supportive. And if problems happen, they've got to know. And of course, in your thing to your steering committee, you've also said what contingencies you may need in the event of industrial action. And you've looked at the past and said, this is the type of industrial action. This is how we would respond to it to maintain production and to avoid a loss to the business. Okay, so they're the things which I think are most important. I've gone well over time, Karen. Next week, by the way, we're going to do the negotiation. Karen, do you have some brief comments?
I think in summary, it's an engagement game in terms of whoever engages better will win. Secondly, just with bargaining, just know the facts, own the story, be consistent. Because if you know the facts, you know the story, you can control the narrative and stay calm and focus on what you're trying to do.
Okay, well, look, that's good. Let's go to the problem. We're going to race the problem today because I'm running late. David was a difficult employee. He was a forklift driver. He regularly pushed the rules around traffic management. I'm speaking as fast as I can. His supervisor, Jeannie, counselled him, re-inducted him on traffic management plan and rules, indicated any further breaches would be disciplinary action. After work, David got home, opened a beer and jumped on Facebook. He complained about how Jeannie was hopeless and a power freak. Several of his connections were work colleagues, and he identified his place of work. After each beer he drank, his comments became more disparaging. We've all seen this, I know. Finally, late in the night, he said, I'm going to get her in the morning. She won't see it coming. See how she feels after she feels a bit of pain. David's best mate is the night shift supervisor. He panics, like I am at the moment, and forwards screenshots to Jeannie. She's very distressed, rings HR at 6 a.m. David starts work at 7 a.m. Let's have the poll. There it goes.
You can breathe.
I'll be caught up 2 minutes. So I think we'll just give it at 15 seconds. I'm sorry, but we'll have to, because otherwise we'll run out of time.
Well, I think people are responding pretty quickly this week as well. So, all right, probably another 5 seconds, everybody. 4, 3, 2, 1. All right, let's end it here.
Okay, so the first question is, can David be stood down? The answer is, under a number of pieces of law, he can be stood down. So the stand down happens where there is an imminent risk to somebody which can't be controlled. That's really the test of in workplace law when you can stand someone down. The safety obligation says you have an obligation to monitor people's health. Jeannie's health is vulnerable at this stage. You have to do everything that's reasonably practical, that is to identify a hazard, determine its level of risk, institute a control using the resources of the business. You could only form a view there is a high risk, and the only control is to separate David from Jenny. So under section 21 and 22 of the safety legislation in Victoria and all comparable legislation, you actually must separate them in a way that is safe to them. And you give David a direction that he is not to publish any further posts on Facebook or any other social media in relation to the business or Jenny. That would be part of the stand down and would be a lawful and reasonable direction that you gave. Okay. So you see we've got the controls in place. The answer is absolutely you should stand the person down. Can the Facebook screenshot be used in an investigation? It can be used both in the stand down, because under privacy legislation, although there is high privacy protections, it is evidence you have received which you can't wait to go around because he can delete it.
Mm-hmm.
And that's the same for using an investigation. So there's jurisdiction is the case that says you're allowed to do it. So you are allowed to use it where it's the purpose of an investigation, where if you waited, the evidence could be destroyed, and where the evidence you have is reliable in its receipt. So you've got a screenshot, it's
Mm-hmm.
reliable evidence. Then the fact that it's got high privacy settings around Facebook, you're using it for the purposes of an investigation at work, it's lawful to do it.
Mm-hmm.
Okay, so am I allowed to do it? Could the employment be terminated after we've talked about Road and Hinterland Motors early on, because he hasn't done anything, he's just said something?
Yep.
And it's equivocal what that's going to be. So Karen, your thoughts?
I think that, yeah, this is serious misconduct because, well, it could be that because there's a threat that the employee may feel as though she doesn't know whether she's going to get hurt or not. She obviously feels that the threat is real.
Yeah.
So you've got to manage on that basis.
So there's two parts to this, and that is workplace law looks at the subjective impression of what occurred, not the objective impression of what it is. So if somebody could reasonably form that view, that's tick. Okay. When you look at what serious misconduct means, and you go to the regulations, Regulation 107, it says the risk of imminent harm. Well, there's a risk there. It's serious misconduct. Is it a crime? Yeah, it's called assault. So battery is actually hitting someone. Assault is can be hitting, but it is also the intention or the threat.
But also go back to the workplace in terms of safety.
Oh no, but I'm just saying in pure Crimes Act, this is a crime.
Yeah.
Okay. There's also a series of Facebook cases and other social media cases that says where someone publishes something where a person could reasonably perceive. So this is the objective test. And it's done during a time of work. This is done during a time of work where it's come from an identified person in a workplace. They would know that person. It becomes a workplace issue at that stage. And therefore you're seized with evidence which relates to work, and you must act upon it under safety legislation. So under safety legislation, quite clearly this person's breached section 25 of the Act, because they're meant to exercise reasonable care. That is a competent person doing their job to not cause risk to themselves or others. Well, they're definitely causing a risk to the other. So do you see when we use the legislation how good it is?
Yep.
We've got workplace law lining up with safety law. So the answer is yes, you could terminate, but we'd need to know a little bit more and go through the investigation.
Yep. All right.
There we go. We got there, guys. That was a bit hurried, wasn't it? I'm sorry about the speed of my mouth, but we got there. And thank you very much for being with us again today.
Thanks for joining us. We'll see you next week.
And we're going to do negotiation next week in the enterprise agreement. Okay. We're going to take in how you use COVID as a disruptor to create that change in the negotiation.
Excellent.
See you later.
Bye,
Thanks
everyone.
very much, Karen, Jane, Mark, Jeanette.
All right. Excellent. All
Okay.
right. Thanks, everyone. We're switching off.
That's over there. You go to end.